Hey guys, in this one, we're going to talk about the I-130, the family petition, and what you should do if your case is denied. I'm Latoya McBean Pompey, an immigration lawyer working with clients globally at McBean Law, where we're helping our clients to achieve the freedom that they deserve. Contact us if you have an immigration problem. You may reach us at 888-462-4006 or at McBeanLaw.com, where you can request an appointment with an attorney. Before you go today, do me the favor of subscribing to our YouTube channel and hit the notification bell so that you'll be the first to get notice of these videos each week. Let's talk about the I-130, friends. The I-130 is the family petition. The petition is filed by a petitioner. The petitioner is usually a U.S. citizen, could be a U.S. citizen parent or spouse or sibling, or an adult U.S. citizen daughter or son filing for a parent. Or the I-130 could be filed by a green card holder spouse, or a green card holder parent who is filing for a child. Once that petition goes into the system, the government is considering the relationship between the two of you. Is it genuine? Is it bona fide? Even if it's a parent filing for a child, is it a bona fide parent-child relationship? Is it a bona fide sibling relationship? Are you guys really related? That's really what's happening there. Or in marriage cases, is it a bona fide marriage? The I-130, once it's approved, it means that the government believes that there is legal, lawful relationship between the two of you, and this petitioner person is eligible to file for you. It is the underlying petition. It carries the entire process from start until finish. And the I-130, if it is ever denied or if it is ever revoked, then there are some things that you could do legally with an attorney to get back on track so that you could get an approval. If your I-130 has been denied, you have to ask yourself the question, well, what is the explanation that the government has provided for this denial? Why did they deny the case? It's always in the decision letter to the petitioner, not the beneficiary. The beneficiary is the applicant. If you've applied for adjustment of status, you're the applicant. Or if you're overseas and you're waiting on your case to be processed, you're the beneficiary or a visa applicant as well, if your case made it that far to a visa application. But if the I-130 is denied, then the overseas case does not get as far as the visa application process. If it's been denied and in that letter it tells the petitioner the reason for the denial, you then have to ask yourself the second question, which is, can I appeal this decision? Is there a basis for me to appeal? And, oh, by the way, can I appeal it within the 30 days or 33 days that the government is giving me? Because you have a very short deadline. If the problem in the I-130 cannot be cured within that 30-day period of time, then the appeal process will not work. In order to appeal the case, you'll need to either show that you have some new facts, new evidence, or the government just got the law wrong or the policies wrong when they were working on your case. And you have to make that argument typically through an attorney to be successful. Is there a reason for you to appeal this decision, and can you do so within that 30 days? And if the answer is yes, I can appeal it, and yes, I can do it within that 30 days. Well, there are forms that can be filed with the government to get your case back on track or reopen. If, let's say, for example, if your case was denied in a marriage case, let's say it was denied because the government did not believe that you two were free to marry each other. Maybe someone was married before and the divorce that he or she had gotten in the past, it's actually not good. It wasn't a good divorce, lawfully speaking, and the government caught that. There is no way that the government will proceed with your I-130 through your current spouse because they don't believe that you were free to marry him or her in the first place. You'll have to cure the problem by getting a proper divorce from the ex, getting a proper marriage, a second one to the same person, your partner, your spouse, of course, starting over with a new I-130. You cannot appeal the decision if the basis of the decision is you were never divorced to begin with. You have to start all over again with a new case. If that's the reason reason for the denial? Well, that could be cured in the way that I've just shared with you. If the I-130 is denied, let's say in a parent-child context, and the government doesn't believe that you're really the parent. This is not your daughter. This is not your son. We don't believe that. Even though you've given us a birth certificate showing your name on it, we still don't believe it. They have their reasons sometimes, guys, for not believing this parent-child relationship. But if they do not believe the parent-child relationship, that too can be cured with primary evidence as well as secondary evidence. The government in its process will send you, before they deny such a case, they normally will send you a notice of intent to deny the case and tell you, here's what we see is wrong with your case, and please fix this by this deadline. And if you're able to cure by their deadline, there you go. But if you cannot cure it by their deadline, again, you'll have to cure it and then start over with a new filing, a new I-130 case. With the parent-child relationship, it can get very tricky, particularly in cases where the child or the adult child, so to speak, had gotten a birth certificate that was issued years after his or her birth. And this is very common for certain countries. The government requires additional proof in those situations. And then if the parent is a father, it gets even more complicated. If it's a father, child was born out of wedlock, not within the marriage, right, between the two of them, it gets very tricky and more evidence is required to prove that the father is indeed the father. Other reasons for the I-130 denial, it could be something that has to do with a previous marriage. If you had a previous marriage that was filed with immigration and that case didn't work out because either the government called you out for what they believe to be fraud or alleged that you've committed fraud, it was a fraudulent relationship, it wasn't a genuine marriage, that older marriage, it will impact this current I-130 that you're filing through your current spouse. So that's another reason why they would deny a new I-130. After the denial of this type of case, the last thing I want to leave with you in this one is after the I-130 has been denied, it's really, really critical that you work with a professional who knows how to handle these types of situations and prepare a stronger case for you, because you need your green card or you need to come to the United States and be with your relative. So get a professional to work on your case. You could reach out to us. We handle I-130 denials. We know how the government thinks about these issues and these problems, and we've seen it from many, many different ways, many different angles of the problem. Reach out to us at McBean Law. We'd be happy to speak with you about your case and how we could help you get back on track to get in your approved I-130. If the I-130 is not approved, then that's it. You can't go any further with your case. It is carrying the entire process. Think about it like this. It's like an umbrella, right? It's carrying everything. It's carrying everything, so to speak. Everything falls under it. Reach out to us. Don't forget, again, to subscribe to our channel and hit that notification bell. And then also subscribe to our firm's newsletter so that you'll be in the loop on additional Q&As, tips we share, good news stories, and immigration news on Fridays. It was such a pleasure to be with you in this one. Share with others. Comment below. Let me know your thoughts on this. And guys, I will see you in the next one. Bye-bye.